Good evening. Today is Friday, July 3rd, 2026. I'm Rich Stevens, and this is the Cold Take. What you're about to hear is news from the week ending Thursday, July 2nd, taken only from primary sources like press conferences and court documents. You can find those sources and attribution for every story at thecoldtake.com. Tomorrow is the semi-quincentennial celebration of the 1776 signing of the Declaration of Independence. The 4th of July is my favorite holiday. I love it. You don't have to. It is a free country after all. 250 years ago tomorrow, the Second Continental Congress formally adopted the unanimous Declaration of the 13 United States of America. 13 years later, when the Constitution replaced the Articles of Confederation, Congress sought to form a more perfect union. At the Cold Take, we understand that the path has never been perfect and often wasn't pretty. But my sincere hope is that while we smoke briskets and cigars, watch Joey Chestnut house 5 dozen hot dogs, and that one neighbor try to blow his fingers off, we can each take a moment. Pause and reflect not on what we lack, but on the extraordinary freedoms we already enjoy. And in that reflection, think about those 3 words: more perfect union. The framers argued and debated, they traded barbs and insults, but they remained united, and their words have endured for 2.5 centuries. We each have the choice to work toward a more perfect union or to surrender that responsibility to those who benefit from keeping us divided. Happy Independence Day from the Cold Take. Cheers. Now let's get into the news. We begin in Washington, D.C., where Monday, June 30th, the Supreme Court ruled that children born in the United States to parents who are in the country illegally or temporarily are citizens at birth under the 14th Amendment. The case challenged President Trump's Executive Order 14160, which directed federal agencies not to recognize birthright citizenship for certain children born in the United States when the mother was unlawfully or temporarily present and the father was neither a United States citizen nor a lawful permanent resident. The administration argued that the 14th Amendment's Citizenship Clause was never intended to apply to anyone born on American soil. Solicitor General D. John Sauer told the court that the phrase, quote, subject to the jurisdiction thereof, requires complete political allegiance to the United States, and that the amendment was adopted after the Civil War to guarantee citizenship to formerly enslaved Americans and their children. That argument also relied on the original Senate debate over the 14th Amendment. Introducing the language in 1866, Senator Jacob Howard said the amendment would not include, quote, persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers, but would include every other class of persons. Supporters of the executive order argued that the statement, along with the Civil Rights Act of 1866, shows the amendment was not intended to grant automatic citizenship to every child born in the country. The challengers argued that the Supreme Court settled the issue in its 1898 decision in United States v. Wong Kim Ark, which has long been understood to recognize birthright citizenship for nearly everyone born in the United States. Chief Justice John Roberts wrote that Wong Kim Ark controls the case and that the 14th Amendment protects citizenship for children born in the United States to parents who are unlawfully or temporarily present. Justice Clarence Thomas dissented, joined by Justice Neil Gorsuch. Thomas wrote that the court's interpretation departs from the original public meaning of the Citizenship Clause and argued that being, quote, subject to the jurisdiction of the United States requires complete political allegiance, not simply being born within the country's borders. Justice Samuel Alito also dissented. He wrote that the majority's interpretation grants citizenship to virtually everyone born in the United States, including children of people who entered the country unlawfully or temporarily for the purpose of giving birth. On Monday, June 29th, the Supreme Court ruled that Mississippi may count absentee ballots postmarked by Election Day and received up to 5 business days later. Mississippi law allows some voters, including college students away from home and senior citizens, to vote absentee. The Republican National Committee, the Mississippi Republican Party, the Libertarian Party of Mississippi, and individual plaintiffs challenged the rule, arguing federal law requires ballots in federal elections to be received by Election Day. Justice Amy Coney Barrett wrote for the court that federal Election Day statutes set the day by which ballots must be cast, but do not set a national deadline for when ballots must be received. The court said the statutes, quote, say nothing about ballot receipt, and held that Mississippi's law is not preempted. Justice Samuel Alito dissented, joined by Justices Clarence Thomas and Neil Gorsuch. Alito argued that the electorate's choice is not complete until ballots are received by election officials, and that counting ballots received after Election Day means the choice does not occur on Election Day. On Monday, June 29th, the Supreme Court ruled that police conducted a Fourth Amendment search when they used a geofence warrant to obtain Google location history data. Police investigating a bank robbery in Virginia obtained a warrant requiring Google to identify devices near the bank around the time of the robbery. Google eventually gave police 3 names. One of them was Okello Chatri, who was later charged in federal court. Justice Elena Kagan wrote for the court that people have reasonable expectation of privacy in their cell phone location data, even when that data is being held by a third-party technology company. The court did not decide whether the warrant itself was valid, whether it had enough probable cause, whether it was particular enough, or whether the evidence should be suppressed. Those questions go back to the Fourth Circuit. Justice Ketanji Brown Jackson concurred, joined by Justice Sonia Sotomayor. Jackson said she would go further and hold that parts of the search violated the Fourth Amendment. Justice Neil Gorsuch also concurred. He agreed that this was a search, but said the court should rely on the Fourth Amendment's protection for, quote, persons, houses, papers, and effects, instead of the modern reasonable expectation of privacy test. Justice Samuel Alito dissented, arguing the court should not have taken the case and that the majority improperly expanded Carpenter into another area of digital privacy law. On Tuesday, June 30th, the Supreme Court ruled that states may limit girls' and women's school sports teams to biological females. The case was West Virginia v. BPJ, decided together with Little v. Heckox. West Virginia and Idaho both passed laws defining eligibility for girls' and women's sports by biological sex. BPJ is a biological male who identified as female and sought to compete on girls' cross-country and track and field teams in West Virginia. Lindsay Heckox challenged Idaho's law after seeking to compete on women's college sports teams. Justice Brett Kavanaugh wrote for the court that Title IX allows schools to maintain separate girls' and boys' sports teams based on biological sex. The court also held that the laws did not violate the Equal Protection Clause. Kavanaugh wrote that safety and competitive fairness are important government interests and that schools may determine eligibility for girls' and women's sports based on biological sex rather than gender identity. Justice Clarence Thomas concurred, writing that a man does not have a legal right to compete against women just because he believes he's a woman. Justice Neil Gorsuch also concurred, focusing on Title IX as a federal funding law and saying that Congress must speak clearly when attaching conditions to federal money. Justice Sonia Sotomayor dissented in part, joined by Justices Elena Kagan and Ketanji Brown Jackson. Sotomayor argued the court allowed an absolute ban even when an individual athlete's case may show no athletic advantage. Justice Jackson also wrote separately, saying the court did not need to decide that Title IX protects only biological sex in the sports context. On Tuesday, June 30th, the Supreme Court struck down federal limits on how much political parties may spend in coordination with their own candidates. The case was National Republican Senatorial Committee v. Federal Election Commission. Federal law limited coordinated expenditures by party committees, including spending on ads and other campaign activity discussed with a candidate's campaign. Justice Brett Kavanaugh wrote for the court that the limits violate the First Amendment. He said political spending is political speech, and Congress cannot restrict campaign spending simply to reduce money in politics or level influence among speakers. The court overruled its own 2001 decision, which had upheld those limits. The outcome is that political parties may now spend unlimited amounts in coordination with their own federal candidates. The majority said existing contribution limits, earmark rules, disclosure requirements, and bribery laws are enough to address corruption concerns. Justice Elena Kagan dissented, joined by Justices Sonia Sotomayor and Ketanji Brown Jackson. Kagan wrote that the ruling allows a party to serve as, quote, an alternative checking account for a campaign. She said a donor who can give only $7,000 directly to a candidate now can give more than $550,000 through a joint fundraising structure, with the party able to turn that money into direct campaign benefit. On Tuesday, June 30th, the House voted 420-0 to release records on taxpayer-funded sexual misconduct settlements involving House members. House Resolution 1399 directs the House Ethics Committee and the Office of Congressional Workplace Rights to publish a consolidated list within 60 days. The list must name each House member, delegate, or resident commissioner who was the subject of a covered sexual harassment, sexual abuse, or sexual misconduct matter if taxpayer funds were paid. The list must also show the total taxpayer amount paid next to each name. The resolution also requires aggregate totals for other settlement categories, including House employee cases and non-sexual misconduct settlements. Wow. On June 10th, the Minnesota Board of Pardons voted to pardon Tao Lu Vang, a Laotian national who pleaded guilty in Ramsey County to first-degree criminal sexual conduct involving a 10-year-old child in 2005. According to the Department of Homeland Security, Vang entered the United States in 1994, lost his legal status after the conviction, was issued a final order of removal in 2006, and was the subject of an ICE detainer. DHS says he was scheduled to be removed from the United States upon his release before the pardon was granted. The Minnesota Board of Pardons consists of Governor Tim Walz, Attorney General Keith Ellison, and Minnesota Supreme Court Justice Natalie Hudson. Under Minnesota law, a pardon requires the governor and at least one other board member to vote in favor. Minnesota says a pardon sets aside a criminal conviction and removes many of the legal consequences associated with that conviction. DHS says the pardon could interfere with Vang's removal from the United States by affecting the conviction that formed the basis for his deportation. Moving away from politics and into current events, on Tuesday, May 12th, Acting ICE Director Todd Lyons said Homeland Security investigations identified more than 10,000 foreign students claiming to work for highly suspect employers through optional practical training. OPT allows eligible F1 foreign students to work temporarily in jobs related to their field of study. USCIS says standard OPT can last up to 12 months, and certain STEM graduates may apply for a 24-month extension. Lyons said the 10,000 students were found among only the top 25 OPT employers reviewed and called it, quote, only the tip of the iceberg. ICE said investigators visited problematic OPT worksites in Virginia, Texas, Georgia, Illinois, New York, New Jersey, North Carolina, and Florida. They found empty buildings, locked doors, residential addresses listed as worksites for hundreds of students, and multiple employers claiming the same address without leasing the facility. In North Texas, HSI said investigators visited 18 OPT worksites in 1 week. One employer claimed to have only 3 foreign students working through OPT, while DHS records showed more than 500 students claiming to work there. ICE also described suspected shell companies, shared websites, offshore management, missing employment records, phantom employees, and financial transactions moving across multiple countries. GAO warned in 2014 that ICE had not fully assessed OPT fraud risks and lacked complete information on whether OPT students were actually working in jobs related to their studies. GAO reported again in 2022 that ICE still had incomplete OPT employment data. Lyons said the fraud is deliberate, coordinated, and criminal, and more enforcement actions are coming. On Wednesday, July 1st, the Department of Justice announced federal charges against 8 alleged members of Tren de Aragua in separate kidnapping death cases out of Texas and Illinois. DOJ says all 8 are illegal aliens believed to be from Venezuela who entered the United States illegally between December 2021 and April of 2024. In Illinois, 3 alleged Tren de Aragua members were charged with kidnapping conspiracy and kidnapping resulting in death. The criminal complaint says a man was kidnapped in Chicago on May 18th, taken to an apartment, then moved to an abandoned building with his hands bound behind his back. Police found him dead the next night in a bathroom, shot multiple times, and badly beaten. In Texas, 5 alleged Tren de Aragua members were indicted on racketeering charges involving murder, kidnapping, robbery, bank fraud, and firearms offenses. DOJ says the case stems from the kidnapping of 3 people on August 24, 2024. The defendants are also charged with murder in aid of racketeering. DOJ says all 8 defendants face up to life in prison if convicted, and 5 face the possibility of the death penalty. On Wednesday, July 1st, 2 Russian nationals broke into restricted areas of the Empire State Building, climbed onto its 1,454-foot antenna, and forced an NYPD emergency service unit response. According to the criminal complaint, a lock on the security door to the 104th floor was broken. That door leads to the building's broadcast antenna, which emits high-frequency radio signals powerful enough to harm the human body. Officers had to wait about 30 minutes while the antenna was powered down before they could reach the climbers. Both were charged with felony burglary, felony reckless endangerment, and felony criminal mischief, along with criminal trespass, criminal tampering, possession of burglar's tools, and disorderly conduct. They were arraigned Thursday, given supervised release, and are due back in court August 24th. Click subscribe, and you'll be notified when there's updates in this case. Markets rebounded across the board this week. The Dow Jones Industrial Average closed at a record high of 52,900 after gaining 1,024 points, nearly a 2% increase. NASDAQ recouped almost half of last week's loss, picking up 535 points, a 2% gain with a close of 25,832. The S&P 500 saw a 1.75% gain, 129 points, pushed the index to finish out the week at 7,483. Even gold stopped the skid, picking up $69, following the market trends with a 1.7% increase. Futures trading closed at $4,151 per ounce. And in sports, last weekend, Formula One returned to Austria, where George Russell converted pole position into his second win of the season, holding off Max Verstappen and teammate Kimi Antonelli at the Red Bull Ring. Verstappen finished second after a late charge, while Antonelli rounded out the podium to keep his championship lead intact. 8 races into the season, Antonelli leads the Drivers' Championship with 171 points. Russell's victory moves him into second with 131, followed by Lewis Hamilton on 125. Oscar Piastri sits fourth, just ahead of Lando Norris and Charles Leclerc. Defending champion Max Verstappen is in seventh. The series now heads to Silverstone this weekend for the British Grand Prix on July 5th. The World Cup has reached the round of 16, and the United States is still alive after a 2-0 win over Bosnia and Herzegovina. Folarin Balogun scored his third goal of the tournament before being handed a red card for stepping on a Bosnian defender's ankle. Playing with 10 men, the U.S. held on before Malik Tillman added a late free kick to seal the win. Balogun will miss Monday night's round of 16 match against Belgium because of the automatic red card suspension. Elsewhere, Paraguay produced one of the tournament's biggest upsets by eliminating Germany in a penalty shootout. Brazil, France, England, Spain, Portugal, Mexico, and Canada also advanced as the round of 16 gets underway. Wimbledon is through the first 2 rounds, and several big names are already out. 7-time champion Serena Williams returned to singles at Wimbledon for the first time in nearly 4 years, but lost in the opening round. American Ben Shelton was also upset in his first match. Meanwhile, defending champion Jannik Sinner, 7-time Wimbledon champion Novak Djokovic, and former champion Carlos Alcaraz remain in contention as third-round play gets underway. The round of 16 begins this weekend as the field narrows toward the July 11th and 12th finals. Finally, in Major League Baseball, the Yankees have lost 7 in a row, while the Rays have won 8 straight. The Bronx Bombers now sit 4 games back in the AL East. In the Central Division, the White Sox are tied with Cleveland and sit 4 games ahead of the Twins. Similarly, in the West, the Rangers and Seahawks are tied with a 2.5 game advantage over the Astros. In the National League, the Braves are just 2-8 over their last 10, and their advantage in the East is now only 2.5 games over the Phillies. In the West, though, the Dodgers have a 13-game lead on the Padres. In the Central Division, Jacob Misiorowski and the Brewers still hold a 5-game advantage over the Cubs. It also looks like scheduling will keep Miz from pitching in the All-Star game, which is disappointing but understandable. And like it or not, that's what happened. I'm Rich Stevens, and this has been The Cold Take. All I can say about these Mensa kids who climbed to the top of the Empire State Building is, if I were the police chief, it would have gone more like this. Initiate the Kong Protocol. Shoot to kill. Happy 4th of July, everybody. Rich Stevens, out.